Hey guys, it's Jenny Silver with an unemployment overpayment waiver update for you. Today on Monday, February 7th, the Department of Labor has issued new guidance for the states, which changes and clarifies exactly who the states can grant unemployment overpayment waivers and blanket waivers to. First, today's video is sponsored by Pershing Square Law Firm. Pershing Square Law Firm is California's first and only law firm dedicated to EDD law. They represent clients in appealing any kind of adverse decision made by the EDD, whether it is a denial of benefits, overpayments, procedural or computational issues with your claim. They represent claimants undergoing any of these issues. In the 8 years they have been in business, they have maintained an A+ rating and accreditation from the Better Business Bureau. They offer a flat rate fee and do not operate on percentages, so claimants keep almost all of their benefits. Pershing Square Law Firm understands that their clients are undergoing financial hardship and therefore their pricing is intended to be very accessible to most people, even those undergoing such financial hardship. Lastly, they offer a complimentary consultation, and anyone facing legal issues with the EDD can call into Pershing Square Law Firm and receive helpful information and get questions answered directly from an attorney through a free consultation. Click on the link in the video description in order to contact Pershing Square Law Firm. Today, the Department of Labor, who is responsible for issuing the rules that the states must then follow with the unemployment programs, has issued this new guidance, which slightly changes some things and makes these waivers available to more people and clarifies exactly the process that the states must undergo. But I want to break it down for you so that you know exactly who may be eligible for an overpayment waiver or a blanket overpayment waiver that would apply automatically to large groups of people. There are a few criteria which must be met in all circumstances in order for any claimant to be eligible for an overpayment waiver. The first is that the claimant has committed no fraud. A fraudulent claim will never be subject to an overpayment waiver. If a claimant has committed either eligibility fraud, meaning that they provided false information with the intent to receive benefits, or if they provided identification fraud, then they are not eligible to receive an overpayment waiver. The next requirement is that the individual was both without fault, that recovery would be contrary to equity and good conscience. Now, in order to be without fault, the individual must have provided all information correctly as was requested by the state. However, if the individual provided incorrect information due to conflicting, changing, or confusing information or instructions from the state, then the individual is not at fault. Additionally, if the individual was unable to reach the state unemployment department despite their best efforts to try to obtain clarity on what information was needed, then they are not at fault. And finally, if they had similar difficulties such as education, literacy, or language barriers, which resulted in them providing incorrect information, then they are also not at fault. So as long as the individual is not at fault, then next the state must also determine that repayment would be contrary to equity and good conscience. Now they have a table defining exactly what that means. One factor is that it would cause severe financial hardship. Each state has a different specific definition for what severe financial hardship means. In the state of California, the California EDD states the following table as the gross monthly income that would be the maximum in order to determine a severe financial hardship. The next factor that would qualify would be if the recipient of the overpayment can show, regardless of their financial circumstances, that due to having to repay these benefits, that they would have relinquished a valuable right or changed positions for the worse. And the last qualifying factor within this table is that recovery would be unconscionable under the circumstances. One of these qualifying factors from these three separate options must be present. Next, the waiver options that have been made available to the states are optional. The states may choose on a state-by-state basis if they would like to utilize any or all of these waiver options. The Department of Labor has created 7 scenarios in which states can opt to offer what's known as a blanket waiver, meaning that they issue a generalized waiver for a specific set of claimants all at once. There is no application required. This first group applies to PUA, FPUC, which was the additional boost, MEUC, and PEUC programs, as well as the first week of regular unemployment. Now, if an individual was answering their biweekly certifications and they answered that no, they were not able to work and were not available for work, but then they received payment, then the EDD may have reached out to them through a phone call or some sort of contact to try to obtain more information. If the individual confirmed the no answer, or if they did not respond to the EDD's request for more information, and then that resulted in an overpayment, then that can be waived with a blanket waiver. The next scenario applies to individuals who were eligible to receive unemployment benefits, but through no fault of their own, they were instead incorrectly paid under a different program, such as PUA or PEUC, at a higher weekly benefit award amount. Also included in this group of claimants are individuals who were given an incorrect weekly benefit award amount for PUA based on the regular disaster assistance amount, which would be due to the fault of the state unemployment department. Both of these scenarios would be eligible for a potential blanket waiver. The next group includes individuals that answered no to being unemployed, partially unemployed, or unable or unavailable to work because of the approved COVID-19 related reasons, and the state paid them PUA anyway. Upon requesting a new self-certification, the individual either did not respond or the individual confirmed that none of the approved COVID-19 related reasons were applicable, and the state's payment resulted in an overpayment for that week. This would be eligible for a potential blanket waiver. The next group of claimants includes those through no fault of their own were paid by the state a minimum PUA weekly benefit award amount based on disaster unemployment assistance guidance that was higher than the state's minimum PUA. This means that basically the state messed up how they calculated your benefit award amount, and instead of utilizing the minimum $167 that they should have used for the minimum, they paid you more. Also included in this group are those who provided their earnings documentation, but the state incorrectly calculated and processed those documents, which resulted in a weekly benefit award amount that was too high and an overpayment. Those individuals would be eligible for a potential blanket waiver. And the last group of claimants who would be eligible for a potential blanket waiver are those who complied with instructions from the state to submit proof of self-employment earnings to be used in establishing eligibility for the MEUC boost, the Mixed Earners Boost. However, through no fault of the individual, the state's instructions were unclear. This resulted in the state incorrectly processing the calculation using incorrect self-employment income or based on documents from an inapplicable tax year, resulting in an overpayment. These individuals could potentially receive a blanket waiver. Now, this is not a change, but rather the Department of Labor goes on to reiterate the lengths that the state unemployment departments can employ in order to collect these overpayments if someone does not qualify to receive a waiver and has not made their payments. They state that this can include other activities such as state income tax offsets, wage garnishments, civil actions, property liens, and collection agency referrals. So if you are in my own state of California, what does this mean specifically for your California EDD overpayment notice? EDD has stated in their press release today that they have received the documentation released by the Department of Labor and that they will next be deciding exactly what they will choose to implement in the California Unemployment Department. I hope that was helpful in terms of getting down into the exact specifics of what the newest updates are with today's release from the Department of Labor and what it may mean for those of you that currently are undergoing an overpayment.